Welcome to another episode of Front Row, and we have here with us today, we warmly welcome Professor Bruce Collins, Queen's Counsel, Australia, with extensive experience in all matters relating to arbitration. Professor Collins has been with the International Court of Arbitration in Paris for many years, and we have a lot of questions for him with regard to all of the ADR mechanisms that we are hoping that we will see in this country. Professor Collins, I think you are aware that Sri Lanka is faced with a serious problem of laws delays. This is a concern not only in Sri Lanka but the world over, and we can see how countries have responded to address this need. If you look at the Sri Lankan scene, there is a focus on attracting investment, foreign direct investment included, and there is a lot of enhanced commercial activity. All of this means that there is a lot more contractual engagements between parties. It means also that there is a need to have an efficient and meaningful regime for enforcement of those contracts. Our ease of doing business index ranking is being weighted down tremendously by the inefficiencies in relation to contract enforcement. It is in this context that the Ceylon Chamber of Commerce, along with the Institute for the Development of Commercial Law and Practice, I will refer to them as ICLP, have partnered to launch a new company, the objective of which is to establish a center to provide alternative dispute resolution mechanisms for the resolution of disputes relating to commercial matters. Professor Collins, what are your thoughts on prospects for success? And by that I mean, what are the features of arbitration and mediation, both of which we will be offering through the center, that makes these mechanisms better for contract enforcement and dispute resolution?
Dhara, I think that when you consider the aspirations of the people of Sri Lanka in terms of economic development, the development of a financial hub, the intention of winning foreign investment into Sri Lanka, that all of those aspirations will be helped, will be significantly influenced by the establishment of the ADR Centre. The fact of the matter is that arbitration, and that's not to minimise the importance of mediation, but arbitration now is an activity which is examined by investors, by business all around the world, and what they want to see when they make their investment decision is a settled country, and there's no doubt that Sri Lanka is a settled, peaceful country. They look for an intelligent, vibrant business and legal structure, and they look to now, I think, in every instance, whether or not their disputes can be solved by arbitration. As to Sri Lanka itself, I'm firmly convinced, having spent a week talking to you and your colleagues, that this centre will be a success, to directly answer your question. And my reason for saying that is, well, they are quite simple reasons. Firstly, Sri Lanka is a clever country. It has wonderful universities, a very strong education system. Its Chamber of Commerce has been here since the late 1800s and has operated successfully. I think the judiciary is, and I say this with great respect, very, very sound. I think there are some wonderful judges in Sri Lanka, but the fact of the matter is you must not allow a perception to remain alive in the mind of foreign investors that the jurisdiction or that the judges are not fully informed or familiar with arbitration. And they need to understand two things. One is that when the parties have decided to refer a matter to arbitration, that's the way they want it decided, by arbitration. And two things follow from that. Firstly, the judges must understand that that is the wish of the parties. And for hundreds of years, those wishes have been heeded. The second thing is that parties to an arbitration do not like to see undue interference or delay in the courts. There will be instances where the courts will need to work hand in hand with the arbitral tribunal, but the mechanics and the indicia of a good arbitration are really indicative of the fact that the court didn't need to do anything except enforce the award. And in Sri Lanka, you've got the great benefit of having acceded to the New York Convention, which ensures that your awards here will be enforced in every country in the world which has also acceded to the New York Convention, and there's something like 140 of those. And you also have the great benefit of enacting in your Arbitration Act the provisions of the model law. So for all those reasons, plus the clever country that Sri Lanka is, I'm very confident actually that this will work, that the effort is going to be well worthwhile, and when foreign investors understand the thoroughness that you've applied to this, Dhara, I've got no doubt it'll be successful.
So thank you, Professor Collins. That is our dream as well. That's our vision for the centre, and we will be having rules for mediation as well as for arbitration. And so litigation is court administered and adopts the adversarial approach, while alternatives are exactly that. They are alternatives to litigation. And what are your thoughts on the benefits of a non-adversarial system that will help or assist or aid better, meaningful and more effective dispute resolution? The key features of ADR.
Yeah, the key features of ADR, just splitting it up into mediation and arbitration, although there are other means by which parties can have expert-assisted mediation, expert-assisted expert determination. But I think mediation's success rate in other countries around the world makes it of considerable importance here in Sri Lanka, and I rather think that the cultural approach of Sri Lankans is probably leading towards mediation. We know in China, for example, that mediation has been very successful, and in my view, so far as mediation is concerned, it has a proven success rate in all of the Western countries, and there is no reason why it shouldn't be successful here. As to arbitration, one of the main reasons why people want to arbitrate is that it's confidential. Its confidentiality is, in all of the surveys, recognised as of considerable importance. And of course your arbitrations here will be confidential, and it's my view, and I know we talked about this earlier, that arbitrations conducted properly will almost certainly be cheaper and quicker than cases in court. And the court's caseload is so great that in most countries in the world, courts recognise that arbitration is a very important adjunct to the overall interest of the community, particularly the business community, in settling disputes.
Thank you, Professor Collins. It has been our privilege to have you on this program.
Thank you, Dhara, and good luck with the centre.
Thank you.